Okay, well, we'll get started. It is 1:30, and we got a critical mass of attendees so far. And we're getting piano requests already, Larry, so we'll get started. Welcome, thanks for joining us. My name is Eric Hauge. I'm the Executive Director of Homeline, and you're joining us today on Wednesday, November 18th at 1:30 in the afternoon for another one of our series of COVID-19 webinars related to tenant landlord rental housing issues during the pandemic. And today we're joined by a number of people, but our special guest is Larry McDonough, the Senior Minnesota Counsel for the National Anti-Eviction Project with the Lawyers Committee for Civil Rights Under Law. We're going to get to Larry in just a couple minutes here. But I have a couple things up front. Just a reminder about what Homeline is. A lot of you have been joining these weekly, but we have new folks every week too. So Homeline's been around since 1992. Our main program is a free and confidential legal hotline that any renter in the state can contact and get advice about their housing situation. And we've advised over 250,000 households since opening. We do advise folks in English, Spanish, Somali, and Hmong languages. And we have a staff of 23, which has increased just in the past couple of weeks as we prepare for calls to our hotline regarding evictions after the pandemic, after the suspensions potentially end. Just a reminder, this is our hotline. So if you are a renter in the state, you can call our free and confidential legal hotline, 612-728-5767, or the toll-free number. We also have direct language lines there as well. We are going to cover general legal information today, like we have in past seminars. But if you are a renter and have questions, that's how you can get an answer to your specific question about your housing situation. And just a reminder that we have been doing these since about mid-April. Originally it was weekly. We're not doing them as often. We've had guest speakers in the past few webinars, including today. And so our next webinar will be on Wednesday, December 2nd. No guest speakers, it'll just be Managing Attorney and Hotline Director Mike Vraw and myself discussing any updates and answering questions. We also got a question, and maybe there'll be more questions that come in today. We got a question in advance today about potentially from a renter, just asking generally about how do I organize a tenants meeting. So that's actually something that our organization does do in addition to our free legal hotline, is that we do tenant organizing. And so we're actually starting to advertise for a seminar the following day on December 3rd, where that's designed for an audience of tenants and tenant advocates. And our organizing staff, one of our organizing staff, Aaron West, will be leading that and discussing some of the steps you can take to form a tenant association if folks are interested in that. All the previous recordings of our weekly webinars related to the pandemic are on our website, as are a number of other resources, a general legal information page, and some specific FAQs on topics. All on our website, homelinemn.org, and there's a COVID-19 tab. And just a pitch that tomorrow is Give to the Max Day. So our organization is a nonprofit. We rely on contributions from clients and individuals to keep our programs free and to preserve our hotline and our programs across the state. So if you have the time and the dollar, please feel free to visit our website there, and you can submit a donation right from our website. Just the logistics for today. There were some questions also from folks about the last seminar. Our last seminar was on October 28th, and it was a 90-minute session. We just got approval for CLE credit for that one. So if you attended that one, you should have gotten an email from Deb in our office here. If not, let us know, and we can get you the CLE code for that. And then for today, we have applied for CLE credit, another 1.5 credits for today. just have applied. So we'll send out the information about that credit after the fact once we get approval. Larry is going to take us through a good number of slides, and we did get some questions submitted in advance, not a ton, but you are welcome at any point throughout the seminar to submit your questions, preferably via the question and answer Q&A Zoom tool. And if they're relevant, we can get to them during the seminar. Otherwise, we will save some time at the end to answer some of the questions that were submitted in advance, as well as get to any remaining questions at the end as well. And then we'll post the materials and the recording from today on our website and send that out to everybody within a couple days. So with that, I think I'm done talking here. Yep, I am. I'm going to stop sharing my screen, and I'm going to hand it over to Larry McDonough, who is, again, with the Lawyers Committee for Civil Rights Under Law. And Larry's got over 30 years of civil litigation practice and teaching. He's represented tens of thousands of clients, renter clients, and has really written the book on how to defend evictions in Minnesota. So I'm going to hand it over to Larry, and he'll pop the slides up. Thanks, Larry.
Yeah, thanks a lot, Eric. I'm happy to be here. I'm one of the fortunate people who was around at the formation of Homeline way back in the day with Charlie Warner and folks at Community Action of Suburban Hennepin County. And it's nice to see it blossomed into the organization that it does. I don't think any of us really envisioned that it would have as many components as it does now.
And one quick thing, Larry, sorry, I forgot to mention this. We also have on the webinar today, both Mike Varr, our hotline director and managing attorney, as well as one of our new staff members, Rachel Sterling, who is heading up sort of our COVID eviction response. And so they're going to jump in with questions here and there if they come in, and we'll try to interrupt you appropriately. And otherwise, we'll leave it to the end and have some space at the end for questions. Thanks.
So one technical issue, Eric, I'm not able to share my screen at the moment. I'm getting a signal that says host participant screen disabled the screen sharing. And you're muted at the moment.
This made you the host, so can you do that? Can you do it now?
I'm good now.
Sorry about that.
No problem. So the slideshow that I'm going to go through 2 slideshows today, and they're both posted on my website. It's called Housing Law in Minnesota. It's part of a website called Poverty Law for a class that I co-teach at the University of Minnesota. If you either Google my name, Larry or Lawrence McDonough in Poverty Law, you'd find the website. The way you get to the housing page is you navigate down on the left to Housing Law. And you can see there are a lot of different topics here. What we're going to be covering today is pandemic eviction. And both of the slideshows, the first slideshow is the eviction estimates, and that's what we'll be doing first. And then after that, we'll be going into more detail on eviction defense strategies right now and when we're past the executive order in Minnesota. So I'm going to breeze through these slideshows a little bit so that we have time to talk. So I may skip over some portions. Feel free to take a look at the slideshows on your own for areas. I'll tell you a little bit about what I'm covering and what I'm not covering. So this first slideshow is really focused. It just talks a little bit about the executive order that's in place right now, more in the context of what's going on in the economy and how tenants are impacted by the economy and by that executive order. The second slideshow, which is longer, will go into issues related to analyzing eviction cases under the executive order and afterwards. Okay. This is a revision of a slideshow that I first put together last month for the Minnesota Council on Foundations. This has my contact information. I just updated the slideshow for this presentation. So briefly about the executive order that's in place right now. Probably many of you know about it. It's 2079. It's the successor to an earlier executive order that stopped evictions that started on March 24. This one became effective on August 4. And it has, essentially, it stops non-payment of rent evictions but it doesn't stop obligation to pay the rent or rent from accruing. It does not affect late fees. And there are a number of exceptions. The main exceptions are violations of Minnesota Statute 504B.171. We'll discuss that when we get to the second slideshow, but it essentially deals with various types of illegal or criminal activity on the property, mostly focusing on, I'd say most of the cases I've seen in that area have related to illegal drugs on the property, but there are some other types of activity that are governed by it. If the tenant seriously endangers the safety of other residents, or if the tenant seriously endangers the safety of other people, if that's governed by the lease. Next, if the tenant significantly damages property, again, if it's governed by the lease. And a fairly kind of interesting and, in my view, kind of an odd exception, if the tenant holds over after a notice where the landlord is saying the landlord's going to move onto the property, or a family member is going to move onto the property within 7 days. The reason why that's kind of an odd one is you're analyzing whether the case fits that requirement on a future event that hasn't happened, whether that person actually moves onto the property or a family member moves onto the property. Any type of case that's filed under these exceptions does require at least a 7-day written notice before the filing of the case, but that notice could be longer based on what is stated in the lease. Okay, so a couple of other things that are at play right now, and I'll go into more detail about these in the second slideshow, is the CARES Act. You've probably heard of the CARES Act, and you might think that it's old news because that was the basis for people getting expanded unemployment benefits, and it was basis of a national eviction suspension during the summer. A lot of that has passed, but there still is a provision without an expiration date that requires a 30-day lease termination notice for types of properties covered by the CARES Act. And we'll go into more detail in the second slideshow about what those properties are. It's essentially federal, public, and subsidized housing, but also rental properties with federally backed mortgages. And it's not easy for everyone to find out if they have a federally backed mortgage. And so that makes it a little bit amorphous for people trying to figure out, am I covered by the CARES Act and do I have to give that 30-day notice? So a covered property, the 30-day notice would essentially replace the 7-day notice that's required under the Executive Order 2079. So we have another player here, and that is the CDC eviction suspension order. And you may have heard about that. This cropped up in September. I think September 2nd, went into effect September 4th. It really caught a lot of us in the housing community by surprise. There wasn't, people weren't thinking the CDC was going to jump in, but the CDC did jump in. And that executive order really doesn't have much impact here in Minnesota because it really only applies in states that don't have greater protection. And the Executive Order 2079 has greater protection. There are more exceptions to the CDC suspension than to 2079. So I think its applicability here is not real relevant at the moment. There is a question as to whether the exception in 2079 that allows the landlord to give a notice to move family members onto the property, or the landlord itself, whether that could be preempted by the CDC order, because that aspect of 2079 is less protective of tenants than the CDC order. And so we'll talk about that more in a few minutes. So the CDC order runs until December 31, but again, its applicability here is, I think, kind of questionable at this point. I'm not going to go into the details of it right now because I'll do that in a few minutes. So even though evictions aren't available for non-payment of rent right now, I certainly do not encourage tenants to just view that as a rent holiday, because the rent will continue and does continue to accrue. There are a number of financial assistance programs that are available to tenants with money that came from the CARES Act, and I've got a list of those here. I've got, for the state of Minnesota, Hennepin, Ramsey, and Anoka County, but other counties have funds as well. One way to figure out what's out there, if you're looking for one place to contact, it would probably be United Way 211 could direct a person to the right program. So what happens when Executive Order 2079 ends? Well, it depends a little bit on when it ends. Right now, it is effective through December 14, and I'll talk about kind of the timing of that in the second slideshow. Whenever it ends, the CARES Act 30-day lease termination notice provision remains in effect until it is changed by some other act of Congress. But that would only cover covered properties, those federally covered properties, and we'll talk about those more in a few minutes. The CDC suspension might still be in effect if Executive Order 2079 would end before the end of December. I think that's unlikely. I think 2079 will probably last longer than the CDC suspension order. And of course, it's always possible the CDC will extend its suspension order as well. And we don't know what the new Biden administration might do on eviction issues, whether that guidance would come from the CDC or whether it would come from HUD or whether it would come from enactment of Congress. So we'll have to wait to see on all that. Other things that'll still be at play whenever 2079 ends is orders of the judicial branch dealing with how evictions are being handled, and we'll talk about that more in a few minutes. We also have a law from one of the special sessions this summer that allows the courts to play around with deadlines for court actions that are imposed by statutes. And some of those are relevant in the eviction area. We'll talk about those in a few minutes. That statute provision will end 60 days after the end of the peacetime emergency, or February 15, 2021, whichever is earlier. My best guess is that the peacetime emergencies are going to continue for some time. And so it's possible that if there's nothing enacted on this subject, that this provision would lapse on February 15, 2021. So I want to talk a little bit about what the tsunami or the flood or whatever you want to call it is going to be when evictions open up more broadly. Most eviction cases are for non-payment of rent. Some of the stats I've seen on it are kind of in the 90% range. So now I'm going to get a little nerdy and go into some data with you. And some of this is rough data, some of it's more precise. There are about 16,000 eviction cases per year as of 2017, or about 1,300 a month. And Hennepin County, about 6,000 a year, or 500 a month. Minneapolis, 3,000 a year, about 250 a month. Anoka, about 1,000 a year, or about 90 a month. If the suspension were to end on December 31, and I actually think it's not, I think it's going to go longer than that given the numbers that we're seeing right now, we would essentially have an 8-month backlog. And so if you just did some simple math, you would see that, okay, that'd be about 10,000 or more statewide, 4,000 Hennepin County, 2,000 Minneapolis, 720 in Anoka. Okay. What would bring that number down is that some tenants might have moved, some might have negotiated with their landlords and figured out payment plans. Some tenants might have that were evictable for non-payment of rent, maybe are back at work. And some might have received some financial assistance. So that would bring the number down if we ignored the economy, but we can't ignore the economy. And the data there is pretty stark. Unemployment in Minnesota is high. In September, it was 6.0. That's twice as much as it was before the pandemic started. Another way to look at it, though, is the cumulative unemployment insurance applications during the pandemic. And we see that it ranges anywhere from about 1/3 of the workforce by county up to 2/3 of the workforce. Okay, so what that tells us is that over this time period, people were unemployed. Now maybe some of them are back employed, but they still might have a rent arrearage from when they were unemployed. And so these are really large numbers in my view. I'm going to move past some of the national data here, but there, I just want to highlight that it's not surprising to me that the unemployment rate might be higher among renters because they're more likely to be working in the industries that have been deeply affected by the pandemic. So I'm going to go past some of this research and get local. So part of what I've been looking at are Census Bureau household pulse surveys. It's something the census started doing during the pandemic where they do weekly surveys. And the survey sample is actually pretty good. The survey sample for Minnesota was a little under 7,000. And according to the Minnesota Housing Partnership, roughly the same number of households they estimated back in 2019. So it's a decent sample. And what that sample showed is about 37% of renter households reported at least one adult unemployed, and 50% had reported a loss of employment income. And this was as of mid-October. I was shocked. I did not anticipate such a high unemployment rate among tenants. I thought it would be high, but not that high. Some other data that we have, the percentage of tenants paying, paying what we call a rent burden, a higher amount of income for rent than 30%, is generally 50% around the state, whether you're looking at the Twin Cities or elsewhere. I'm gonna skip past some of the national data and go back to looking at the census information here. I've got links here so you can go to these websites. I haven't gone back to them since I looked in mid-October, and so I'm probably going to go back and look at those in the next couple of weeks and see what the data is showing. But anybody can go to these links here. These are some of the tables that they have related to renters and homeowners, and so I was looking at this in mid-October. And again, what I was, so a number of things here I found, about 9% of tenants were reporting that they were behind on the rent. And again, here's the unemployment and loss of income percentages there. And even more telling information, when asked about confidence to pay the next month's rent, basically only 52% reported a high confidence, and about 20% reported either no or only slight confidence that they would be able to pay the next month's rent. And with a smaller sample, and I'm not sure why it was a smaller sample, but a smaller sample of about 1/10 of that earlier sample responded to the question about the likelihood of having to leave due to eviction in the next couple of months. And essentially 50% were saying either a somewhat likely or very likely. And again, this is a smaller sample, and if you just want to roughly extrapolate that out and multiply that number of 30,000 by 10, you get 303,000 to have a number that's more in conformity with the larger sample we were looking at earlier. Okay, that's a pretty large percentage and a large number of renters saying, I think I'm going to be evicted in the next couple of months, most likely due to rent. And note that the tenants are saying this at a time when evictions for non-payment of rent are suspended right now. So that tells you the kind of fear and apprehension there is out there. Not surprisingly, people of color are more at risk. There's a different type of unemployment calculation where you look at a 6-month period and you kind of soften out the ups and downs of the unemployment rate. And when you look at that for Minnesota in September, looking back 6 months, it was 7.8. So it was higher than that 6% earlier because the unemployment rate has come down a little bit. Okay, but when you look at African Americans, their percentage was twice that, more than twice that, and 3 times higher than what that percentage was a year ago. So that shows you how this is really impacting people of color. So I'm sorry to be the bearer of kind of dark news here, but homelessness in Minnesota, it wasn't very peachy before the pandemic. We had a very high record of a record high of unemployment before the pandemic, and it's not just tent accumulations that people might have seen around the Twin Cities and other localities. That was simply because people were aggregating. The unemployment or the homelessness rate was already high. It was just less visible because people were dispersed, became more visible when they aggregated closer together. During the pandemic, the cost of housing the homeless has skyrocketed. And so homelessness is a big issue right now, even without a flood of evictions. And there's reporting that attorney representation of tenants increases favorable outcomes and makes them less likely to be homeless and less likely to need government assistance. So let's look at eviction estimates. And I'll be honest, they're all across the board. And it's hard to know where they all fit because of everything's so uncertain right now. But Stout did estimates around the country, and they were estimating between 60 and 75,000 potential evictions in January. Keep in mind, 16,000 evictions statewide in Minnesota in 2017. The Aspen Institute did another estimate. Theirs was higher. They were estimating 281,000 tenants might be subject to eviction based on the assumption of a 30% unemployment rate. And again, the unemployment rate for tenants in Minnesota is 38%. Okay. It's really hard to know what to make of these estimates. They kind of make my head explode. And so maybe I'm naive. I mean, maybe they're right, and I'm just naive. Things to think about is the census data. I mean, 37% unemployment, 50% loss of income, 9% saying they're not caught up, almost 20% reporting, not a lot of confidence in paying the next month's rent, and potentially, 300,000 people thinking that they're going to be evicted in the next couple of months. When I managed the housing unit at Mid-Minnesota Legal Aid, I regularly handled over 300 cases a year. Well, most of that was advice. But in the high point of my time as a staff attorney, and I was pretty active staff attorney, I would go to court maybe 3 to 5 times a week and handle 1 to 2 trials a month. The housing unit at Mid-Minnesota Legal Aid, which covers Hennepin County, has 14.5 attorneys. And kind of a rough estimate is that they'd maybe be able to do full representation in 15 to 30 cases per month in Hennepin County. And that'd probably be on the aggressive side. So my conservative estimate of what we might be looking at if things opened up in January would maybe be about 10 times the pre-pandemic number of evictions. Maybe I'm being naive and setting it that low, but that would put 13,000 statewide, 5,000 Hennepin County, 2,500 in Minneapolis, 720 in Anoka County. And that would simply overwhelm legal aid programs doing housing work. The other thing that I've been looking at just this last week are the health impact of renewing evictions during the pandemic. There's a new modeling study out of Johns Hopkins University and the University of Pennsylvania that looked at kind of the impact of evictions on transmission of the virus. Essentially finding that if there are a lot of evictions, the impact of that would be households would merge with each other, increasing the size of households, and that would increase the chance for viral transmission because the science is showing that viral transmission is happening in close contact with people as opposed to when you're out and around, walking around and things like that. This model did not include the effect of homelessness in shelters and encampments. It was really looking at consolidation of housing and saying that this really could have a profound increase on a virus transmission and really supported having eviction controls in place as a public health issue. And that's essentially what the CDC was doing with this eviction suspension order. And it's hard to put a number on this, but what they saw is definitely an increase in infections and deaths that would occur if housing units are consolidated because of the eviction and displacement of some households. And I've got links to both the abstract and the full study and also some reporting on that. So what can you do? Well, you can go to seminars like this, and you can volunteer, and you can donate to free legal aid programs and volunteer programs that represent tenants. I've got a list of them here for those of you in the Twin Cities. You've got Volunteer Lawyers Network and Southern Minnesota Regional Legal Services and Mid-Minnesota Legal Aid, Central Minnesota Legal Services, and on kind of the side of the Twin Cities, you've got Judicare of Anoka County. Legal aid staff programs are finite in size. If there's going to be an expansion of legal representation of tenants when things open up more, it's going to have to come from outside of legal aid organizations. So essentially private attorneys, corporate counsel, folks that don't work in legal aid programs rolling up their sleeves and helping. And also donating to these programs could potentially allow them to expand their service. Other ways you can participate. There are advice programs out there, online legal advice through Minnesota Legal Advice Online. Homeline has a tenant hotline service that relies on volunteers. Law students can get involved through Minnesota Justice Foundation placements. People can get involved with mediation programs and help landlords and tenants resolve those disputes, even if you're not representing them. And also you can support tenant organizing, like Eric was discussing earlier, organizations like Homeline and also United Renters for Justice. And also you can support and volunteer with housing policy and litigation organizations. And I've got a list of those here as well. And lastly, you can advocate. If you think policies ought to continue to protect tenants in the pandemic, that protection is happening from the governor, but you can also be talking to your representatives. There are also department heads that are concerned about housing and housing justice rights, but also be talking to city and county officials as well. So with this, I'm gonna stop this slideshow and I'm gonna jump into the other one.
Larry,
so, yes.
Just to give you a second to have a sip of water if you want to give yourself a quick second. We had a question come through that I think, you talked a little bit about how we don't really know when the moratoriums are going to end because we don't know when the peacetime emergency is going to end. But I guess how likely do you think it's going to be that it's going to be just an on-off switch, or how do you think that there might be like some sort of on-ramp solution in place by the time this does end up?
Well, those are conversations that those of us that advocate on the issue are having with the governor's office. Evictions have expanded out from the very first eviction suspension order in March. And so that was a kind of modest reopening in evictions. But the bigger question would be, if you are going to open up non-payment of rent evictions, that's essentially the flood. I mean, if 90% of those cases, are non-payment of rent, I don't know a graduated way of opening that up. And ultimately, that may very well fall on the court system to decide, are we going to then limit how many filings we're going to take as time progresses? And the special session law from last summer, I think, gives the courts that ability to do that.
Thank you.
Okay. So the second slideshow is longer. I'm going to start with kind of a brief kind of a roadmap for the slideshow and tell you what I'm probably able to cover and what I'm probably not able to cover, and you can look at the rest of it on your own. So I first presented this slideshow in May, and I've revised it several times since then to take into account the progression of things that have happened over the summer. So I'll what I'm going to spend my time on today is really on eviction issues. And we'll talk about, a little more in detail, Executive Order 2079, the CARES Act, the CDC order. We'll talk briefly about mortgage foreclosures and court rules, but that'll be kind of the chunk of where I'm going to spend the rest of my time today. Some of the things that so basically what's discussed on this slide, I'm going to try to cover in the next, about 25 minutes or so. Things I'm probably not going to cover today, but you can feel if I get to it, if I end up drinking coffee, which unfortunately I don't drink, and end up talking faster, which I probably won't, maybe I would get into some of these things. But you can take a look at some of these things on your own if I don't get to them. Okay, so what we're going to discuss are the executive order and the federal laws that I've highlighted a little bit already, and talk a little bit about foreclosure, court orders, and kind of go down that road. So I'm going to start a little bit historically because it gives you some context for where we are right now. The first executive order was 2014, and that started on March 24, and that was a broader executive order than 2079, what we have right now. So 2079 supplemented and replaced 2014 effective August 4, and I'll be talking about that in a few minutes. The executive orders stopping evictions run in tandem with the peacetime emergency declaration by the governor. And essentially what the governor does is he does that for 30 days and then renews it every 30 days. So the current one goes until December 14. I would be shocked if we don't see another one that takes us into January and maybe even further. And you read about this probably in the newspaper, every month or so, the governor says, I'm going to go for another 30 days, and he gets the legislature back in session. And most of the time, the Republican Senate has said no, the Democratic House has said yes, and they wash each other out and continues on. Interestingly enough, and it might be because of the numbers that we're seeing right now, the Republican Senate did not oppose extension of the peacetime emergency. Every time the governor extends the peacetime emergency, it extends the eviction suspension by reference. Okay, so the very first suspension had a number of definitional sections. It covered landlords, property owners, mortgage holders. It covered the officers that enforce writs of recovery. But with financial institutions and mortgages, it only requested that they stop foreclosures. But the executive order required stopping evictions. So with foreclosures, they could continue the foreclosure process, but could not commence the eviction action based on the foreclosure process. So the executive order stopped the filing of evictions and the termination of leases and the execution of writs. There were some exceptions. 504B.171 is one we'll spend a little bit of time on in a few minutes. And importantly, non-payment of rent is not an exception. So this stopped the very large kind of supermajority of eviction cases. Executive Order 2073 expanded the eviction suspension a little bit because the first one just basically said 504B.171. And it had that, and also if the tenant seriously endangers the safety of other residents. So make sure I'm kind of going in the right direction here. Okay, here we are. So 2073, this summer, expanded that serious endangerment exception to include people other than other residents, but only if that was governed by the lease. So serious endangerment of other residents did not require a lease provision to be the basis for it. But serious endangerment of people other than other residents required a lease provision providing that as a cause for eviction. Okay, so let's talk about 504B.171, which was covered by both of these executive orders and the current one, 2079. So it covers unlawful controlled substances allowed on the property, certain prostitution offenses, certain firearms offenses, stolen property or property obtained by robbery on the premises. And then you have different ways of talking about illegal drugs on the property, so not using it to manufacture, sell, give away, barter, that type of thing. Then there were other provisions of 504B 171 that govern domestic abuse, criminal sexual conduct, and harassment. Now, there is a defense in 504B.171 related to the drug provisions that says that the provision is not violated if the tenant did not know or have reason to know of the activity. Okay, so if someone else brought the drugs on the property and the tenant didn't have reason to know or knew, that would be a defense to a violation of this statute. Other defenses related to drugs are in 609-5317, that the tenant could not prevent illegal drugs from being brought onto the property, and also medical marijuana use under 152.32 would not be unlawful use and therefore not a violation of 504B.171. So some defenses that are relevant to the earlier executive orders, and those provisions are also in the current executive order, would be that the plaintiff still has to prove the exception to the executive order by a preponderance of the evidence, would have to prove 504B.171, and I already discussed some of the defenses that are available under 504B.171. Related to the other exceptions, the landlord would have to prove that the tenant not only endangered the safety of other residents, but seriously endangered. And when we're looking at persons other than other residents, they'd have to show again endangerment, that it was serious endangerment, but also that that conduct was governed by the lease. Let's see, is there something else I wanted to say there? Let me just go back a second. And so other defenses to consider are defenses that are available in other types of eviction cases, like waiver, domestic abuse, relief from forfeiture, retaliation, reasonable accommodation of disability, and others. Okay, now there are some exceptions to the coverage of these executive orders. For instance, officers that had basically priority writs or writs issued under 504B.171 were ones that they could enforce, and also the serious endangerment of an eviction order writ based on that they could enforce. And so sheriff officers are governed by the executive order, both in what they can do and what they can't do. The executive order did not apply to federal trust land and did not preempt localities from going further. Violations are a misdemeanor, and the Attorney General's office has taken, I think last I heard, maybe 1,500 complaints of violations up to this point and have prosecuted a number of them. The executive orders did not suspend mortgage foreclosures, but did suspend evictions based on them. So Executive Order 2079, it replaced these early executive orders. It remains in effect. And essentially what it did is it added some other issues onto it, okay? So what it included are serious endangerment, safety of other residents, like the earlier executive orders, 504B.171, but then also added the issue that I talked about at the beginning, where the landlord could have given notice based on wanting to have other family members move in. I'll get into the details of that in just a moment. Material violation of the lease by seriously endangering the safety of others. That was in the earlier executive orders, but it added significantly damaging property. So paragraph 4 of the new executive order allowed the landlord to terminate the lease with a 7-day notice with the intent that the owner or property owner's family would move onto the property within 7 days of when it's vacated by the tenant. This is a challenging kind of ground to analyze with a tenant, because whether the tenant wants to stay or not would be kind of based on whether the tenant thinks the landlord is really being legitimate and accurate about moving in, or a family member, in 7 days, but you don't know that at the time of the date when the landlord's telling the tenant to move out. So that's kind of a tough one to analyze, whether the tenant should stay and fight that or not. And that's really an odd kind of decision-making process, to be basing your decision as to whether to challenge a notice based on an event that doesn't have to happen until 7 days after you were supposed to move out. Executive Order 2079 changed the rules for sheriff deputies to conform with the expanded causes for eviction under 2079. The other thing 2079 added was to require a 7-day notice before filing an eviction. Rachel, did you have a question for me?
I did. I wanted to wait till you got through the rest of 2079. We had a couple of ones come through that were regarding this particular executive order. So I wanted to wait till you were done with it.
Yeah, you can go ahead.
Yeah, one of the questions that I thought was pretty good was about the family exception, but the question was if a property owner sells the property, does that meet the exception for the landlord needing to move in? So say someone is renting a house and sells it, and the new owner wants to move in.
I think that might fit, because essentially there's nothing in 2079 that bars the sale of rental property. And if the new owner, who then is becoming now the new landlord because he or she takes the property subject to what the old landlord had, would now be the landlord. And if that landlord was looking at moving onto the property, or having a family member move on, if they gave the right kind of notice, I think that would fit. Now, I don't think the selling landlord could give that notice before the new landlord owns the property, because the old landlord would not be intending to move his or herself or family member onto the property. So I think the new owner would have to take over the property, become a landlord, and then give the proper notice. And right.
And that would be the same thing, even if it was, say, a multi-unit area where if the landlord is selling the place and the new owner wants to move in to one of the units, they have the same ability to do that with the proper notice.
Yep.
Okay. And then the other question we had come through was about are any of these things, obviously these things are executive orders, so they end when the peacetime emergency ends, but do you know if anything has been discussed about with the Minnesota legislature to make some of these protections more permanent, while also potentially allowing landlords to actually process evictions?
Yeah, so there was some lobbying going on this summer about having legislation that would really pick up on what was done in the executive orders. And I think it would be fair to say there was a lot of legislative dysfunction this summer, and none of that happened. And so pretty much when the legislatures come back into session, other than I think the bonding bill that happened this fall, it's simply been a discussion of, is the peacetime emergency going to continue? I frankly think the executive orders are going to continue into the next legislative session, just given the kinds of numbers that we have in the pandemic. And so we'll have to see what happens when the legislature gets back into session in January.
Okay. And then final question that we have so far, kind of relating to these executive orders, is these exceptions about the illegal activities or the damage or the threatening behavior, it has to be happening on the property, correct?
Correct.
Right. Easy enough.
Yep. Okay. So continuing on, let's see. So paragraph 6 of the executive order required a 7-day eviction notice basically saying, here's your notice that I'm going to file an eviction case in 7 days. And that would be required for all eviction cases. And I know of some eviction cases being dismissed for not having given that notice. So similar to the other executive orders, it's a misdemeanor to violate it. Tribal trust land is not covered by it, and localities can go more protective of tenants if they want. I haven't seen that happen yet, probably because these executive orders have been pretty protective. So I'm going to kind of slide through some of these slides here because I think I've already covered how Executive Order 2079 expanded upon the earlier orders. So I'm going to move on move past these slides and go through this one fairly quickly. So defenses that come out of 2079, some of them are similar to what we discussed before. And it's really about analyzing each exception and figure out if, for instance, with the significant damage to property exception, did the tenant materially violate a lease provision discussing property damage by significantly damaging property? And so I think the operative words there would probably be material and significant. And you can kind of see that I've italicized on these different slides where I think kind of the litigation points are going to be with these different exceptions. When we're talking about endangerment, is it serious or not? Things like that. Other defenses, whenever you're litigating in a kind of a subject matter specific area, and now we're litigating under even a narrower subset, cases that are available under Executive Order 2079, it's a good idea. It's important not to kind of, lose the forest by just, looking at a tree. So don't forget about other analytical frameworks. Is service of the case proper? Was there a waiver of a notice? Was there retaliation, waiver of breach, domestic abuse? Could relief from forfeiture, an equitable principle apply? And issues of expungement and attorney's fees. Not enough time to go into all that, but a lot of that's discussed on my housing website and in my answer forms. Law enforcement has liability for violating executive orders, and I've trained law enforcement. I don't know if we have any law enforcement folks on the call today. They have liability for violating the executive order, and so my advice to them is to require a landlord to show documentation that the writ fits the exceptions, like the eviction complaint and the eviction order, to make sure that this isn't, you could have, let's say, an eviction case for non-payment of rent and 504B.171, and the court looks at 504B.171 and dismisses it, doesn't think the facts are there, but then grants a writ for non-payment of rent because the judge might not be familiar with the parameters of 2079. Then it comes to the sheriff. The sheriff deputy, if that enforces that order, has liability for violating the executive order. Essentially, it would be a misdemeanor. So I think a sound practice would be for them to just require documentation that shows that the order is based on a case that fits the exceptions. So I already talked a little bit about the CARES Act. What I just want to, and I'm going to go through this slide fairly quickly because I do want to end around 2:30 so we have time for more kind of random questions or questions that come to people's minds. So I'm going to go through these fairly quickly. What I wanted to mention here with the CARES Act, what I talked about earlier, are the two things that come out of that. Is it suspended late fees for covered properties for the period of March 27 to July 25, and the 30-day notice for covered properties is still in effect. So let's go and talk about what a covered property is. Well, it's rental property. That one's not too hard. Then what it defines are covered properties as being properties covered under the Violence Against Women Act. And that ends up being a huge cross-reference to all kinds of subsidized housing programs that are connected to the VAWA Act, and also rural housing programs and federally backed mortgages. So subsidized housing cases covered by VAWA, it's a pretty long list. For those of you that don't do subsidized housing law, this is just alphabet soup. And if you're not working with those programs, you don't need to know about that. In the legal aid world, these would basically be all the different subsidized housing programs that you see in your practice. Then there are rural housing programs that are more outside the Twin Cities that have their subsidized housing programs as well. And there are ways to look up whether properties are in these subsidy programs, and I've got a link to that. Now, what's a little more opaque is properties that have federally backed mortgages. Why do I say that's opaque? Okay, I own this house where you see me sitting in St. Paul. I couldn't tell you if I have a federally backed mortgage or not. I bought it 15 years ago. I'd have to go look at the paperwork and try to figure that out. But it doesn't matter because I'm not a landlord. But if I were a landlord, I'd need to check, because if I have a mortgage insured under one of these programs, backed by one of these programs, then I would have to give the 30-day notice under the CARES Act before filing an eviction case, rather than the 7-day notice under Executive Order 2079. There are ways to look this up, and I've got some links here to figure out if a property does have a federally backed mortgage. So affected landlords for covered properties, they had an eviction suspension in the summer. That has passed now, but they still are governed by the 30-day notice. And even now, they would not be able to charge late fees for that period from March 27 to July 25, because late fees, they weren't suspended, they were made inoperative for covered properties in that time frame. And some courts are requiring landlords to submit an affidavit that if they are covered by the CARES Act, that they're in compliance with it. So it's really important for landlords to figure out if they have a covered property, and it's really important for tenants to figure that out as well. This is the provision that requires a 30-day notice for covered properties, and it does not have an expiration date on it. I'm going to kind of skip past the differences here. I think I've already kind of made that clear, but this slide kind of shows you the differences between the CARES Act suspension and the one under Executive Order 2079. So now enter the CDC. It has an order stopping essentially non-payment of rent eviction cases around the country. It's less protective than the Minnesota one for a few reasons. First of all, it requires tenants to complete a declaration that has a number of elements, basically saying they're behind on the rent due to employment issues or lack of employment issues due to the pandemic. There are other topics there, but that's kind of the gist of it. So they have to do a declaration to be covered by the CARES Act, and there's no declaration that's required to be covered by 2079. It's also less protective in that it doesn't include motels and hotels and other guest houses that are for rent, and 2079 does not have that exception. So residential motels and hotels and shelters would be covered by 2079 as well. And here's some more information about the affidavit. It also has an income threshold on it that 2079 does not have. So there are quite a few elements of this that are essentially a weaker eviction suspension than 2079. And also the exceptions are broader. The number 5 on this slide would be essentially an exception for violating any provision in a lease. And the exceptions in Minnesota, again, were limited to 504B171, serious endangerment issues and significant damage to property issues, and the renting to relatives. And I'm going to kind of slide past this slide, kind of going through the comparisons, because I think I've kind of covered that already. So I'm going to skip ahead a little bit here. Mortgage foreclosures. Again, to reiterate, our executive order did not stop mortgage foreclosures in Minnesota, but there have been a number of actions on the federal level that have stopped certain mortgage foreclosures, depending on whether they're Fannie Mae, Freddie Mac, FHA, VA, things like that. And so there are a lot of foreclosures that have stopped, but for foreclosures that haven't been stopped by these moratorium, you still couldn't base an eviction case on the foreclosure unless you fit one of the exceptions to Executive Order 2079. So, perhaps serious endangerment, significant damage to property would be potential ones. Okay, so we also have court orders, and we're at 2:30, so I'm gonna take about 5 more minutes just to get through a few slides here, and then we'll open it up for a few more questions. So we've got some court orders out there governing how eviction cases travel. At first, actually the very first eviction suspension was by court order by the Chief Justice in mid-March, but that only lasted for a couple weeks. And when that expired, that's what gave rise to the executive orders. Essentially, the statewide court orders and the district court orders, and whatever district you should in practice, you should go to your district's website and see if you've got a district order on that. What they're essentially doing is making eviction cases and other types of litigation more remote and otherwise less in person. And that is good from a health standpoint, but there are certainly a lot of tenants that don't have access. They don't have computers, they don't have internet access, they can't go to public libraries or courthouses to use those court computers and library computers. And so for people that don't have that kind of access, the court system's going to have to make some variation available through in-person or going to some place where they can use a computer. I was on a call today where I learned that there's a program in place to put some kiosks around the state that would allow people to participate in court hearings remotely. But if they're going to do that, they're going to need some help if they're unrepresented preparing on doing that, because it's a little bit challenging to know what you're going to do with documents and stuff if you're unprepared for a Zoom hearing. I talked a little bit about a special session law, and this allows the courts to essentially disregard statutory deadlines for court proceedings. And where this is going to play out in the housing area, there are a number of deadlines in 504B. I think the one that might be the most relevant in my view are an eviction scheduling, which would allow the courts when they are inundated to schedule evictions out longer, since it won't have the same capacity, especially like in Hennepin County, they won't have that capacity to hear like 30 or 50 cases on a calendar at a time. They're going to have to figure out a way to kind of stretch that out. So I think the courts are going to use that. I think they already have been using that there. Also for eviction continuances, the court would have the ability to extend out. And I think also for a stay of an eviction writ, the court could say we're going to extend that writ out farther to give that tenant more time to move. I've got an eviction answer form that's relevant at this point, and that would be the second one here, A1V1, and you can find it on my housing website under the pandemic evictions. If you are representing a tenant, you can avoid filing fees by presenting the tenant's answer to the eviction complaint orally. If you're going to file a document like my answer form or another answer form, then you should be looking at filing an IFP application as well. So again, just to reiterate, when evictions end, when 2079 ends, whenever it does, what will be left? Well, we'll have the 30-day notice under the CARES Act. If the CDC order is longer than Executive Order 2079, it would still be in effect, and we'll still have the orders of the court and also the special session law on court deadlines up until February 15, 2021. So when evictions open up, I don't have time to go into eviction basics, but eviction cases will be a broader array. Whenever they open up, and non-payment of rent cases are going to be in, you're going to be looking at non-payment of rent issues, and we haven't been discussing that today because those cases aren't proceeding at this point. But I have a lot of information on my website and a manual on how to navigate and dissect eviction cases, and I have answer forms there as well. And I want to encourage tenants attorneys to really think expansively at this point in time. I can't think of a time better than a pandemic to be advocating particularly zealously for the protection of the health and safety of tenants. Whenever non-payment of rent cases open up, the court has the power to give tenants a bit of time to pay the rent. A lot of people think it's limited to 7 days, but there's no statute that limits the ability to pay up non-payment of rent in 7 days. The court has that capacity under the 614 case, I think, clearly to extend that out, because that decision affirmed a 30-day extension to pay rent. And I think within that framework, that could include payment plans as well. In all cases, I think the relief from forfeiture doctrine is something that attorneys ought to be considering. It wasn't very successful pre-pandemic, but again, I can't think of a better time to be analyzing the equities of having a tenant be evicted if the landlord can be adequately protected from non-compliance with the lease. And again, I have more discussion of that in my website. Landlords and tenants should be engaging mediation programs if they're not, to try to resolve the differences that they have. And so I'm going to stop at this point in the slideshow and see if there are other questions. If there aren't a lot of questions, I can certainly proceed into other parts of the slideshow and talk about things like non-payment of rent and late fees and rent gouging and maintenance issues in a pandemic. But let's take a pause here and see where we sit.
Thanks, Larry. So we've got several questions. A lot of them are very detailed.
Okay.
So I'll do my best to kind of categorize them, because we have some are about the exceptions, some are about the court forms and the more notice requirements, and some of the liability stuff. So I'll try and the first one, let's go with, so to utilize the family exception, does there need to be a breach of the lease, or does the lease need to be coming to kind of its natural term?
Yeah, so one of us is cutting out a little bit. I'm not sure.
All right, that's me. I just got that notice that my internet connection is unstable.
Okay, I think I got the gist of that. To use the family exception, that is an independent cause for an exception to the eviction suspension. So you would not need to have another claim like serious endangerment or significant. These are all kind of independently resting causes for an exception to the eviction suspension. I can certainly contemplate a case where there would be multiple ones, where the landlord would like to move a son or daughter onto the property, but the tenant has also seriously endangered another resident and significantly damaged property. So they certainly could be piled on, but they don't have to be piled on. And I would really discourage any landlords from trying to fit a square peg into a round hole. I mean, if what you have is a non-payment of rent problem, don't try to manufacture an exception that doesn't fit. Because if you do that, you are violating the executive order, which means you're committing a misdemeanor, and you could be charged for that. And so don't go down that road. If you really think you have that exception, then go ahead and do that. But if you don't, then don't go down that road, because again, there have been at least 1,500 complaints to the Secretary of State's office, and they have charged landlords for violating it. Now, the charges are probably happening on some of the nastier stuff, like shutting off the utilities to kind of encourage the tenant to leave, and then say, well, I never gave a notice, I never really said you had to go. That type of conduct is going to be a violation of the executive order. So don't even play this straight.
Now, so since this is a relatively new exception for the moratorium, the court forms don't really list it as an option. So if that exception isn't addressed in the complaint, is the landlord precluded from being able to use it, or can they kind of add it in once they get to the trial?
That's a really risky practice. There is case law that's discussed in my eviction defense manual where cases have been dismissed for either inadequate pleading, so you don't plead enough specificity in your complaint, or denying the request to add additional claims on, because evictions move pretty fast. There's summary proceedings, and there have been a number of decisions that said, you play your cards when you have them, you know, and if you need to wait to file the eviction because you're not sure yet, then wait, but don't file the eviction and try to figure it out later, because you might run into a dismissal for inadequate pleading, and you might be denied the ability to add on to your complaint.
Okay. I turned off my video so that I could hopefully stop bouncing my audio around. Kind of going from there, so to give that notice for the family eviction or any of these, how specific does it have to be?
Well, I always encourage all attorneys and landlords and tenants to not be coy, to not kind of hold your cards back. And that's both on the landlord side and the defendant side. I mean, when you do the notice, landlord, I think you should be as specific as possible. Use the facts that you've got. And I personally would not just say, I'm going to file an eviction case in 7 days because you have significantly damaged the property. I question whether that would be specific enough. The executive order does not require specificity in it. There certainly are cases in the subsidized housing world that say that if you just simply give kind of a conclusory ground for eviction and you don't go into factual detail, that you're going to run into problem. And then once you get to the pleading stage, you actually are required by statute to plead the facts that authorize recovery of the property. And so that's why some cases have been dismissed over the years by saying something concludes with a conclusion and not going into the base facts. So if I had a significant damage to property case, I would first of all need to know it's got to be a material violation of a lease provision involving significant damage to property. So I would be citing the lease provision, and I would be specific about the facts that tell the story of significant damaged property. I would put that in the 7-day later, and that might encourage the tenant to think carefully about, do I want to fight this case? I mean, do I think the landlord has the goods on me or not? Or maybe the tenant sees the facts there and says, well, wait a second, you don't know the whole story. Then talk to the landlord, and maybe once the whole story is evolves, the landlord realizes, okay, well, maybe the tenant really didn't significantly damage the property. It was the abuser who broke down the door, who was victimizing the tenant. And so then maybe I shouldn't file this case. The other nice thing about being specific in the notice is then when you file the complaint, you can attach the notice and cross-reference it, and you don't have to restate everything in the complaint, because you can say, you know, we're basically evicting for the allegations that are in the notice. So I've always been a strong proponent, because I've represented landlords too. I've represented both commercial and residential landlords, mostly tenant representation, but I've done that as well when I worked at Dorsey and Whitney. And I would always be a proponent of saying, let's put all the cards on the table.
Sorry, we're getting some follow-up questions here. So Timothy Mallon was wondering, can't you make a conclusory statement in the pleadings and follow up with discovery? Discovery doesn't really happen in these, right?
I think it's a risky practice. You can certainly do upon information and belief, like we all do in all kinds of litigation. So, you know, I really don't, I would never count on discovery as a way to flush things out. These cases move pretty fast. In Hennepin and Ramsey County, there's a housing court rule that authorizes expedited discovery, but it does not require it. And outside of Hennepin and Ramsey County, those rules don't apply. Certainly judges and referees could use them for reference. I'd say the times that I've had discovery in eviction cases in 37 years and 10,000 clients would probably be under 20 times, and maybe even less than that. I think that'd be a risky bet to think that you could develop the facts through discovery, because you may not get it. and you might be facing a motion to dismiss for inadequate pleading, and then you never get to the discovery.
Okay, thank you. One more question about the notices. I think this one's pretty straightforward. It's from Diane. It says, is the 30-day notice a notice to end the lease or a notice of intent to file an eviction action? If it's a notice to end the lease, wouldn't the requirement to file a 7-day notice of intent to file an eviction apply?
So let's go back to, so I'm going to pull up my screen again. I want to go back to the slideshow, so give me a moment here. And I'm going to...
While you're doing that, Larry, I'm just going to answer a couple quick questions that came in advance. Just a reminder that we did put in the chat the CLE code from the last seminar, and you'll get that via email. You'll also get the CLE code for today via email after the fact. We applied today for that. We got a question about if we consider applying for real estate continuing education credit for these classes. Our understanding is that we have to apply 30 days in advance for that. So it's something we might do in the future if there's enough interest. If you want to connect us with folks in that field that would be interested, we might be willing to do a specific training on that. And yeah, that's it, I think. Thanks for letting me interrupt.
Yep. Okay, so this is the provision for 2079. And this type of notice is really, it's a little confusing. So I get the question, because prior to the executive orders, if you had a non-payment of rent case, unless your lease required you to give a notice, you didn't have to give any notice. You could file a case for non-payment of rent on the 2nd if it was due on the 1st. If you had a breach of lease case for the loud party that happened on the 25th, you could file it on the 26th. You didn't have to give a notice unless the lease required a notice. And so for most types of cases with public and subsidized housing and manufactured home parks being the exception, you didn't have to give a notice. And the only time you had to give a notice is if you had a month-to-month tenancy. You would have to give a 1-month notice and a day to terminate that tenancy. And then the eviction that you would file would be for not having moved at the end of that tenancy. If you had a 1-year lease and the 1-year lease ended on a particular date, you didn't have to give a notice under most leases that the lease was ending. And then you would file the case based on the tenant not having moved after expiration of the lease. So the notice that most of us dealt with in eviction cases wasn't for non-payment of rent, wasn't for breach of lease. It was for terminating a month-to-month tenancy for no reason, not non-payment of rent or breach, just I want to end the lease. Okay. So what the executive order, it's a little confusing because it is a different kind of notice. It's saying this is a notice of intent to file an eviction action. Okay. And so it's different than a notice to terminate a lease because the executive order isn't using that kind of language. What's confusing is that it then says, or longer, if there's a specified notice period in the lease. So, you know, I don't have a great answer for you. If you have a lease provision that required a certain amount of, let's say it required a 15-day notice to before you could file a case for non-payment of rent or breach of lease, then I'd say that notice would apply and would go past a 7-day notice. Now, if you simply had a month-to-month tenancy, you don't really have, and it's oral, you don't have a provision in a lease, so then it would be the 7-day notice. Now, some leases have a provision that says that if the tenant wants to extend, if the tenant wants to terminate the lease after a certain period, the tenant has to give a 60-day notice. And so I don't know. I'm not sure what the answer is on that. I guess I'd have to look at the exact lease language and kind of formulate my best impression on that. Because they are kind of two different animals. One is a notice of intent to file a case, and the other is a notice to terminate a tenancy. And the executive order just says the specified notice period included in the lease. And so, you know, I'm kind of going back and forth on this because I haven't seen this kind of case yet. I think there's certainly a plausible argument that if the only type of notice that is specified in a lease is a 60-day notice to end the lease, it's certainly possible that a court would say you had to give the 60-day notice and not the 7-day notice. I suppose you could always take the risk and do the 7-day notice, and if the case gets dismissed, then have the 7-day notice say something like it's a 7-day notice, but if it gets invalidated, it's a notice for a longer period of time, and see if that works. But this provision, the two provisions that are a little bit of a conundrum in 2079 are this one and the family member move into the property one.
Yeah, so basically the only time that you can, in air quotes, get evicted under 2079 is if a landlord has a family member moving in, or there's the significant property damage or illegal activity, or threatening behavior. So what would, for the illegal activity, we just had a quick question about whether you needed a conviction to be able to utilize that exception, or if it was just proof of illegal activity on the property.
No, it's just a civil standard preponderance of the evidence. So if you had a conviction, that would be pretty telling, because that would be a conviction beyond a reasonable doubt, which is a higher standard. So essentially what you do in a criminal activity case is you prove the elements of the crime by a preponderance of the evidence standard. And so if you're not a criminal law practitioner and you are using a particular criminal law cross-reference from 504B171, first of all, it's got to be one that fits into that, right? So for instance, let's say that I get arrested for DUI right as I pull into the driveway. And let's say and so I've engaged in a crime at this point. It's criminal activity, it's on the property, but it's not included in 504B171. Now, if I crash the car into the garage, then I still don't fit in 504B.171, but now I fit under significant damage to property if there's a lease provision that governs significant property damage.
Okay, thank you. I'm going to go try to do a little bit more in order here. David E. wrote one that's, I think it's two-parter, but one is to deal with how does the landlord handle occupant on a post-foreclosed property with no rental agreement, but the tenant is continuing to occupy the premises, and sounds like there's a hoarding situation. So there's standing water, mold is growing, filth and such like that.
Well, not to be too redundant, but you got to fit into one of the exceptions. So expiration of a foreclosure redemption period is not a cause for an exception. It doesn't fit into one of the exceptions. And so it's possible that the facts related to the hoarding might lead to significant property damage, but then the problem you have there is if you don't have a lease provision governing significant property damage, then that is not an exception. Now, if someone were, so it's problematic in the foreclosure world because it's one thing if you've picked up a foreclosed property and there was already a lease, then that lease travels into the ownership of the new owner. And so then you've got some lease provisions there. But if you have a foreclosure of a homeowner and now you're in a post-foreclosure situation, you don't have a lease provision that's continuing on. And so then you're really stuck with whether you can fit something in to 504B.171 or substantial endangerment of other residents, not people other than other residents, because you need a lease provision for that. Or if you're looking to move onto the property, that would be the exception. So the person who bought the property would have to be thinking, I'm not going to do it as rental unless I do it for rental for a family member. So the new owner could look at that exception as a way. But outside of that, more, you know, and I don't want to be kind of insensitive about this. The eviction suspension order is definitely impacting, it's helping people, but it's also hurting some people. So it's certainly some landlords that haven't been able to collect the rent, and hopefully they're now engaging in conversations with tenants and payment plans and looking at financial assistance to do that. It certainly impacts the new owner from a foreclosure, and it's changed the power balance, whether you like it or not. Landlords and property owners, this is a different reality than what you had before the pandemic, and the power balance has shifted. And so you can be crabby about that, and you might be crabby about that, but being crabby about that doesn't change in the balance. And so you need to be thinking strategically about whether you can fit a case within the exceptions to 2079. And if you can't, then you need to be thinking, you know, kind of thoughtfully and, as my mom would say, put on your thinking cap and think about, how can we resolve this problem? Is there something I can offer to the tenant? Is there something that we can do to get either the tenant to pay the rent, or, you know, maybe to, you know, work out some differences that maybe allows the tenant to move? You have to be careful in negotiating with the tenant to move, because you know, if you say, I want you to move, let's talk about it, that I want you to move, if you don't have grounds to move, to do that under the 2079, you're potentially committing a misdemeanor. So the way I would tee up that conversation is to say, okay, well, you're here, and this is, you know, I'd either like to get some rent or I'd like to get the property back. Let's have a conversation and figure out what we can do. But be careful about making statements that would imply that you are making the tenant leave involuntarily when you don't have an exception under the 2079, because that's potentially a misdemeanor.
Yeah, that actually segues nicely into the last. There's about 5 or 6 questions left, and we've only got about 3 minutes left. So are you able to stay on an extra couple minutes?
Yep.
All right. Thank you.
I'm teaching a class at 3:30, and I can probably stay into just a little bit before then.
Okay, thank you. So yeah, a lot of these questions are specific more towards what landlords can do right now. So if, let's see. So can a landlord sue for past due rent before the lease expires?
Yes.
I think the answer is yes to that one. Yeah, you can.
You can do that. You can't sue for rent that's coming due unless you had an acceleration clause in your lease, which is one, uncommon, and I wouldn't be surprised if courts would be a little reluctant to enforce an acceleration clause in a residential lease in a pandemic.
Okay. Let's see that. Shannon had a question about when the orders do eventually come to an end, are the landlords going to be able to evict due to non-payment, or are they going to be giving renters a certain amount of time to catch up on rent? I assume this is the government giving people some time.
Well, that really depends on what kind of, if there are transitional executive orders or transitional legislation. At this point, we don't have any transitions. It is kind of like you're either suspended or you're not. And if the executive order would end, and if there were no legislation on the subject, then essentially it's opening up the floodgates right then. And so the only buffer on that would probably be the court system's ability to manage the flood. And that's where I see the court system basically maybe saying, we're going to cap eviction filings at so many a week to kind of string that out a little bit. That certainly is something I think all of us advocates are discussing, is what that transitional kind of state ought to be. But at this point, we don't have one.
Larry, if I could jump in for a second, I think the governor could do something
Sure.
with some sort of, he's done that with restaurants, with bars. 2079 actually had a lead time of, I can't remember, maybe 10 days, where it was announced that this was going to be the rule. And the rule wasn't in effect yet, but it was said that this is going to be the new rule starting, I can't remember, August 4th or something like that.
Yep.
So the governor, if they're still using the 30-day executive powers, they could try to figure out a way to make this a transitional period versus just, hey, you know what, evictions can be filed today.
Right, and I agree, and that's essentially what I was saying, is that we don't have a transition in place, and those of us that advocate with the governor have advocated that there will need to be a transition, but there isn't one in place, and that could be done by executive order if we're still within a peacetime emergency, or it could be done by legislation. But if it doesn't happen, it's essentially going to be a free-for-all, and I think the court system is going to have to then figure out some way of parsing out its own time, and that in effect would create essentially a delay for some people and not others.
All right. Couple more, I think, pretty straightforward questions, Larry. So Bruce had two. One of them was just a clarification. Basically, can a lease be terminated during the lease term simply because a family member wants to move in, or does the exception only apply to non-renewal notices? And I think
The way I read the exception is it could apply in a lease term. You know, I'm just kind of reading it at its word. I haven't seen any court decisions on that subject. The fact that an eviction notice only has to be 7 days, and I mean, you'd have to have an eviction notice for 7 days saying, well, first of all, you'd have to have the notice saying, I want you to move. And then if the person did move, then give the 7-day notice and then file the case. But as I read it, even though this is not kind of my favorite answer, I think it does allow for that. And I'm guessing the policy behind that, because I've seen the flip side of it. I've seen, you know, college kids saying, I want to get out of the lease and move back with mom and dad. And maybe they want to move back to mom and dad's apartment that they rent. And so I think the executive order does allow that cause to be given in the middle of a term of a lease.
Yeah, and I just don't know that I agree with you on that one, Larry. Looking at the clause, thanks. Looking at the clause in the executive order, it also refers to, it's got the 7-day notice or the specified notice period included in the lease, whichever is longer. So first of all, you've got that potential 60-day argument that you mentioned earlier, which I think is stronger than you portrayed it as. Many leases, especially suburban leases, will actually have on the first page kind of a definition section, and it'll say notice period : 60 days. That's the only real sign we have of a notice period in the lease. So maybe that's what it is. But the other argument would be, hey, look, the lease itself is kind of a notice period in a sense. It's a 1-year lease. This goes for a year. And so you can't interrupt it early because of the fact that you've got a family member that wants to move in. It's more or less the governor giving a new super fast route to an eviction for a landlord that didn't exist pre-COVID-19, which is hard to imagine that that's what he intended. I get your point about the words.
Yeah, and the provision about giving notice to move a family member in, I'll have to go back and take a look at that. It doesn't state a notice period, I think. I think it just states, right? Does it?
Sorry, hang on.
See if I can go back and look at that, but I think it does not state a notice period. It just says give notice that a date to move, and then a family member or the landlord would move in within 7 days.
Right. There's sort of, it's kind of an oddly sequenced thing where you're not exactly sure which paragraphs necessarily cover the entire order. One of the things about this executive order, which I know you think and most of the folks in this world think, is it wasn't completely thought through. This executive order, I understand the goal of all of it, but for instance, family member is not defined.
Yep.
Right? I mean, is it a
Yep.
cousin? Is it a second cousin? Is it a third cousin? Is it a third cousin once removed?
You have a family member.
Right, right. So we don't know exactly, because we've seen other statutes where family members are defined. But anyhow, as you pointed out, there's not a lot of case law on what this executive order means when it comes to the family exception. And I don't know that I've seen any landlord successfully say, I can end your 1-year lease midway through because I want to move in because I just split up with my wife.
Right.
And provision number 12 in 2079 says the EO doesn't create grounds for eviction or lease termination beyond what's already provided for. So it doesn't create something new, right?
Right. But yeah, I agree with kind of everything that's being said here. At the same time, the executive order is kind of premised on what I would say equitable considerations. And I could certainly envision a judge saying, well, the equitable consideration here is the landlord's need to move the kid into the property. And then interpret the executive order that way. But you could also say, the same thing that, like Steve just said in the chat, that it should not trump the 12-month lease. So it should not be something that you should be able to do until the expiration of the lease period. And so I think there are kind of compelling equitable considerations on both sides.
So I think the conclusion there is the courts haven't decided yet.
Yeah, there are a number of things in here. There's some things that I think were really well done and parsed out well, like not just using the word landlord, but talking about property holders and mortgage holders and things like that. So some parts of it, and other parts like family member are kind of left for interpretation. And so we'll have to see. Again, I think the family member one is the most kind of problematic of the exceptions in my view.
Okay, yeah. Couple more, I think, pretty quick questions. Both Roger and Tim B asked if the state federal moratoriums apply to commercial real estate.
So it's interesting because the moratorium language that talks about not being able to terminate leases applies to residential, and to not commence eviction actions applies to residential. But the limitation on the execution of the writ of recovery by the sheriff is not limited to residential. So it creates this kind of odd universe where I think the commercial landlord could file the case but not get an enforceable writ.
Okay. All right. Another landlord, like working around landlord option. Could a landlord file a breach of contract claim? I know you're not a landlord, or you're a tenant lawyer, not a landlord lawyer.
Well, I've done both.
Okay. So, but would a landlord be able to file a breach of contract claim for the past due rents? That's kind of similar to the small claims court, but slightly different.
Yeah, I probably, right. Yeah, sure, you can do that. So, and depending on the amount, you either sue in conciliation court or you sue in district court. Some counties are not calendaring conciliation court cases because there are cases out there of higher priority and others are. And so there's nothing in the executive order that eliminates the obligation to pay rent or to pay late fees. And so a landlord could sue for rent due to date in a non-eviction case and get a judgment. I'm not sure how useful that judgment's going to be in a pandemic, and I'm not sure how fast the case is actually going to travel. Some counties are moving ahead with conciliation court cases and some aren't.
Larry, we got a question the last session we gave, which was a lot, was similar to this, kind of theoretical, what else could a landlord file? An ejectment action. Have you ever dealt with an ejectment action in landlord-tenant world?
Yeah, I'm old enough to have dealt with it because way back in the day, evictions were handled in municipal court and county court, and they had limited jurisdiction. And if I raised a defense that went beyond the jurisdiction of the municipal or county court because it was not statutorily able to consider equitable claims, I would raise that as a defense and move to remove the case to district court and have it heard as an ejectment action. It was kind of a strategic move as well because it slowed the case down. Ejectment actions are a common law kind of predecessor and alternative to eviction actions. They're not used very much because they travel at the pace of conventional litigation. So when Tim earlier was talking about discovery, yeah, you got discovery, you got motion practice, and all the things that make court cases go for months, if not years, as opposed to days, if not weeks. And so the remedy that you have in an ejectment action is ejectment, which one could say is different than eviction. Given the equitable principles that were involved that I just discussed with the, I think, creation of the executive order, I would think would lead judges to interpret the executive order broadly enough to say, no, you're not going to get an end run around this executive order by calling it an ejectment action. So that's kind of but there isn't anything in the executive order that deals with ejectment actions at all. I'm not sure what type of writ the sheriff gets in an ejectment action. I suspect they get an eviction writ because there are probably not enough ejectment actions to lead sheriff's office to have a form writ for an ejectment. And so even if you could do the ejectment action and won, if what you ended up getting at some point, months or years down the road, was an eviction writ, unless you met the exceptions to the executive order, the sheriff wouldn't be able to enforce it.
But your view as an ejectment would be potentially a year or longer. I mean, that's normal pre-COVID times. It would be a year or longer potentially.
Right.
Now, with the courts just covered in molasses, that could be 2 years
Right.
before an ejectment actually wins.
Yeah, I don't view that as a great strategic option for a landlord. I think what landlords need to accept is that there's a different power balance here and deal with that reality. And that may mean negotiating with tenants in realms that landlords had not done in the past. I think the ejectment action is a lengthy and uncertain alternative to negotiating with a tenant.
This is an interesting one. Can a landlord pay a tenant money to move out?
I think so, because again, you'd have to go back to the language and what the executive orders have prohibited is filing eviction actions and terminating leases, essentially involuntary kind of removals of tenants, which is what an eviction action is, and a termination of lease is essentially an involuntary move against the tenant to end their possessory rights. I don't see anything in here that would preempt the landlord from saying, I know I can't make you move, but I think it'd be better for you to move and better for me to move. And so how about let's work a deal? And that deal could be going to pay you some money, going to give you good reference, all kinds of things. And that's not an unheard of analytical framework. Mm-hmm. I mean, you see this in the commercial world all the time, where there's essentially a buyout of the commercial tenant to get out early or sometimes a buyout of the landlord to get out early. So tenant wants to move their business to some other place and says, landlord says, well, no, you're locked in. And so the tenant essentially throws some money at the landlord to get out. Other times when the landlord throws some money at the tenant. We haven't seen much of that in the residential setting. It maybe happens a little more in the high end of the world than the lower rent end of the world. But I'm curious, Mike, if you see any problem with that, but I don't.
Yeah, no problem with that. And we are seeing it a little bit more. The other thing a landlord would offer would be forgiving the debt too, outright, which, might be much more than the actual money due. There's a lot of tenants out there that have some of the money as well. And so they might have the ability to move, but if they owe, $15,000 and they only have $8,000, they're thinking, what's the point of talking to my current landlord? So I encourage landlords to open the lines of communication. And especially if you're thinking about, hey, I got to cut my losses. I don't know when these moratoria are going to really effectively end. I got to get somebody in there that's going to pay. Forgiving the debt and maybe floating the tenant $1,000 might be enough to convince them to go. Might be better for all sides.
Yeah, Steve makes a good point in the chat about cash for keys has been done in foreclosures for a long time. And that's kind of a nice analytical framework, because here we are, at the end of December, we will have been in an eviction suspension for 8 months. Okay, we're starting to close in on the time frame of a foreclosure process when you look at the notice that goes in and the redemption period. And so, banks in the foreclosure world for a long time have said, okay, well, do I really want to wait through this whole process? Why don't I throw some money at the homeowner and see if I can get possession of the property earlier? And so I think for some landlords, that would be a good strategy. Now, they haven't had to do that in the past because the timeframes in an eviction case weren't the same as the time frame in a foreclosure. But given how far we are into the eviction suspension, we're kind of in that time frame.
Well, yeah, the difference between a bank is they knew what the foreclosure process time frame was.
Right.
Landlords don't know that now, though. Although I have to say, with the talk of the vaccines recently, I think that there's probably more likelihood now that we're going to see extensions, with the thought process being from the decision makers, whether it's the governor or the president through the CDC order, of saying, well, you know what, we think this is going to get solved in 5 or 6 months. We're not asking people to hold on for 10 years. Yeah. So maybe we just keep extending things that much more time. I think that's more likely now, with the much more concrete talk of vaccines having a bigger role in the media, certainly. So I think that's something a landlord could and should probably consider from a cost-benefit analysis.
Yep. So I'll probably have to go in about 5 minutes.
Okay. Thank you. We have one more kind of slightly complicated question. So a tenant has abandoned a property, and a new tenant that doesn't sign a lease takes possession of the property. Is that new tenant protected by the moratoriums?
Yeah. I mean, now there's some holes in the facts here that give me a little bit of pause. Mm-hmm. So if that person is a tenant as defined by 504B.001, then I would say the moratorium applies. And the reason I hesitate a little bit is if someone just moved onto the property and they did that unbeknownst to the owner, so essentially someone who's, back in the old days, you'd call it squatting, where mm-hmm. you come on the property. If that person is not paying any rent to the owner, is not providing any services in lieu of rent, like we've got an agreement, I'm going to give you a new roof, and so I don't have to pay any rent. If you're paying rent or doing services in lieu of rent for occupancy of somebody else's property, now you're a tenant. Now, if someone comes onto the property as a squatter, and so the owner doesn't know anything about it, that person's not paying any rent, that person's not providing any service, and then the owner finds out about it, then the remedy there is really more of trespass, saying you got to get off my property because you don't have any right to be here. And if that person refuses, to call the police, because that's a crime to basically be trespassing on the property of someone else. And so sometimes it's a closer call as to whether someone is a tenant or a kind of more in the guest role who could be trespassed.
Okay. And then to confirm with you, Tim had a question about suicidal ideations. Those don't rise to the level of threat because per the executive order, it has to be threatening others, correct? Not just themselves?
Yes, under the executive order, it would be endangering. And so I want to be precise in the language. Yep. The language is not threat. The language is substantial endangerment.
Yep.
And it focuses on other residents or others. So that would not be a cause. Now, there are other remedies for someone who is suicidal. One is to talk to a health professional and about what types of things could be done by talking to perhaps the police. There are commitment proceedings that are brought sometimes by hospitals against someone who's threatening their own life. But I don't see suicidal intent or actions as fitting into the exceptions unless that involved one of the other independent causes. If someone is trying to kill themselves and they're unsuccessful and they endanger another resident, you've got a cause, or if they fit one of the other ones. But I think you'd have to look for grounds outside of eviction and the executive order to deal with that.
Okay, thank you. I know you have to go and we've got a few more questions. I think we've done this in the past where we've just kind of answered them and sent them out to the group later on because some of these I think are a little bit out of our wheelhouse as well. So it might take a while.
Okay. Well, people can get my contact information either from my website here or if you go to the slideshow, at the end of the slideshow, I guess it's already in here. I'm part of my job is to do training in this area and to answer questions, to consult and to collaborate with people. And so I'm very open to getting questions from attorneys and tenants about analyzing their cases. And so feel free to reach out to me.
Thanks again, Larry.
Thank
we
you
appreciate
so
you
much.
coming by today.
Yeah, thank you, Larry, and also thanks, Rachel, for helping ask questions and facilitate today. And just a reminder, I put plenty of stuff in the chat, but we will again send out Larry's slides. Will go right next to the recording on our website once we get that up in the next day or two, and so you'll be able to access that there. And I just wanted to send out another reminder of our next webinar will be on December 2nd. I just thought of it in addition to just generally overviewing the current pandemic situation and suspension situation. The Minneapolis ordinances that impact security deposits and screening requirements go into effect for smaller operators beginning on December 1st. So we may set aside a little bit of time on the 2nd to also discuss that. We talked about those earlier in the summer when they went into effect for larger landlords. So that'll be another topic that we bring up on the 2nd. And when we do get the CLE credit information for today's seminar, we will send that out to participants. So again, thanks to Larry, Rachel, and Mike, and thanks to everybody for joining us today. Have a good rest of your day.